Hello and welcome to the latest edition of the Department's Let's Talk podcast. Today, fresh from the back of his international trip to The Hague, is our guest, Jesse Clarke. Jesse is General Counsel of the International Law and Human Rights Division in the Department. Jesse, welcome.
Thank you very much, Kieran. Pleasure to be with you today.
So, your recent trip to The Hague, what was that all about?
Yeah, well, look, some context. Australia's involved in more international disputes than I think ever before in history. Now, that's not all cases brought against us where...
Is that by design, though? Or?
No, that's just kind of where we are at the moment. So we've got cases in different courts and tribunals, sometimes where the defendant, sometimes where the claimant. And in this case, we were an intervener. So the trip to The Hague was really to represent Australia in its appearance before the International Court of Justice in a case brought by Ukraine against Russia.
So why was it specifically being heard in the International Court of Justice?
Look, the ICJ, as it's known, is the principal judicial organ of the United Nations. Well, what does that mean? Well, it's kind of the court of courts when it comes to international disputes, and often known as the World Court. And in this case, what happened was that Ukraine has a legal dispute with Russia based on its invasion, Russia's invasion of Ukraine in February 2022. And it basically is bringing a claim before the court that was unlawful. And so it's the International Court of Justice that has jurisdiction to hear disputes between states and resolve them. It's a slightly curious body because, it doesn't allow for cases brought by individuals against individuals. It's a state-to-state forum. But it also, unlike domestic courts, doesn't have compulsory jurisdiction. It doesn't have the right to bring all states before it, and it doesn't have the ability to determine disputes under all of international law. So it has a more limited role, and that's really because, like many international mechanisms, it's based on consent.
So how does that work? You've got two countries on the other side of the earth having a dispute with no direct connection to Australia. Yeah,
that's right. So it's unusual because we, Australia, are not a party to the case at all. What is this case about? Well, it's really about Russia's invasion, as I mentioned earlier, and it's part of a much broader suite of legal actions that Ukraine has brought against Russia to hold it to account.
Were many other countries represented as well? Or?
Yeah, there were 32 states intervening. So you've got the parties themselves and then 32 states intervening. And there have only been a couple of cases where states have intervened on this basis. Most notably, New Zealand did it to support Australia's case against Japan about whaling in the Antarctic. But it was very significant to see all 32 states intervene in the way they did. It was significant in terms of demonstrating the interest of the international community in this case, but also the importance that all those states placed on the resolution of this case. And it was novel. The court had to deal with, these 32 states who wanted to all show up and participate, a totally novel experience. And they really were very careful about how they did that. So while they knocked away Russia's objections to the interventions happening, they had to manage the proceedings in a way that was fair to the parties. So they, unfortunately, gave us very short deadlines in which to put in our written submissions, and they confined each intervention to 10 minutes. That was a maximum. And we took a very tactical decision about how to do that. We couldn't cover all ground and say things meaningfully in 10 minutes. So we focused on what we thought was really the key issues in dispute and made some sort of concrete and clear, I hope, legal arguments that will really assist the court in grappling with some of the more difficult or potentially difficult elements with the judgment. And I guess we'll see when we read the judgment how successful we've been in assisting the court in that way. There's a very specific provision in the statute of the International Court of Justice which governs when other states can get involved in a case. But it's right to say that, Australia has no particular interest or role in the dispute. Yeah. So it intervened, along with 31 others, as a party to the relevant convention, and that was the Genocide Convention in this case. So we've been signed up to the Genocide Convention since about 1948, when it was negotiated and agreed. And because the court was going to have to interpret and apply that convention to resolve a dispute between Ukraine and Russia, it allows parties to the convention to come in and share its views, that state's views, of how the convention should be construed. And that's what Australia did.
Does it have to define what is genocide in this situation? I mean, these are two disputing, obviously warring parties. Genocide is an interesting definition to pop in there.
Just recalling President Putin and what he actually said at the time of the invasion, because Ukraine powerfully demonstrated during the hearing that a lot of Russia's actions were justified on this sort of protection of genocide basis. And he said just days before the intervention, the purpose of this operation is to protect people who, for 8 years now, have been facing humiliation and genocide perpetrated by the Kiev regime. So you've got this justification for using force based on prevention of genocide. So really what Ukraine's case is saying is, look, Russia, you said you invaded Ukraine to protect people of genocide. That's a lie, is what their case says. There is no genocide going on in the east of Ukraine, and the ICJ should confirm that for us. And the Genocide Convention itself doesn't authorise states to invade another state to prevent genocide. There's no legal basis in the convention for that.
But how would they investigate that?
So there is already some jurisprudence from the court on this issue, but they can actually go and make factual findings. They can have regard to expert evidence and factual evidence. That'd be for the merits phase, the next phase of the case. But it is within the court's jurisdiction and power to do that kind of fact-finding exercise.
I thought that would be kind of hard to do under the current situation in that it's a war zone now. So
sure, but I think the relevant period would be those 8 years before. And there's plenty of evidence around, from international human rights monitoring agencies, from the UN itself, and even from both countries' work and statements about this. There's quite a body of evidence that the court could grapple with. And it's important because if the court does say, yeah, this is rubbish, there was no genocide in Ukraine, what Ukraine goes on to say is, more than just getting that wrong, you've actually used that allegation as a pretext for an invasion. That's abusive. That's bad faith, says Ukraine. So it's not only factually wrong, but to have purported to rely on the Genocide Convention to use force against Ukraine on the basis of a false allegation is actually to breach the Genocide Convention itself. And that's what Ukraine's ultimate case is, that Russia's acted unlawfully here. The court should say so and should award Ukraine damages and reparations for Russia's illegal invasion. That's ultimately where Ukraine wants to get in its case.
To what extent can it do that, though?
It can order that. Absolutely, it can. It's within its jurisdiction. Whether it'll go that far, we're yet to see. Now, of course, there's a criticism, not without foundation, of international law that these sorts of judgments, in the absence of an international police force to enforce them, are hollow. And look, there's some force to that. The way to enforce a judgment of the International Court of Justice is through the Security Council. Now, of course, Russia sits happily on the Security Council with its power of veto, as do all the permanent members. So there are some definitely flaws in the system for achieving international justice. Nevertheless, it's widely recognised that a judgment from the ICJ is a very powerful tool in international relations, in diplomacy, in negotiations, and indeed in ongoing efforts to put pressure, in this case on Russia, to change its behaviour. So that's probably the greater utility. One further, I think, aspect of why Ukraine wants this is to say to the world, this was a lie. This justification by Russia was a lie. That can't be the reason it invaded. And that's obviously very powerful in terms of their bilateral relations and internationally as a matter of international relations too.
Well, that wraps up part one of our conversation with Jessie Clarke, General Counsel, Office of International Law. In part two, Jessie tells us about how the intervention was received and what happens next.